Appeals. I'm sure you've all looked at the court website. There's that, it says attorney portal on the left-hand side. All you need is a bar card number to access your case, and that's where the clerk's record shows up in your case. It's not actually on the main public page. You have to have that access to your case. But when it gets filed, I would really encourage you to look through and see if everything you asked for actually got in, and if all the attachments to those documents actually got in, because a lot of times there are mistakes on that. I would also look to see if the documents are legible. I'm in a case right now where it was a summary judgment appeal. The two key affidavits in the trial court, for whatever reason, when they got to the Court of Appeals, the font got really large and scooted off to one side, and you couldn't even read the two key affidavits. And it was no big deal. You just went back to the clerk and say, hey, we need better copies. But you know, you'd hate to see that, you know, a couple of weeks before the brief's due, and you haven't got that. So be aware of those little practical things that can happen. Also, it is easy to supplement the clerk's record. There's really no deadline for that. It is helpful, though, if all the clerk's record is on file before you're writing the brief, because otherwise you're having to drop a footnote and saying, well, I haven't gotten the supplemental clerk's record in, but that's what's going to be in it. So try to do that, catch that stuff on the front end. For the appellee, so you've won in the trial court, don't assume that the appellant is putting anything you need in the clerk's record. They're probably not. So just be aware that as the appellee, take a close look at the clerk's record and see what was not included that you know your trial team is going to need when they're writing the brief. Now, the reporter's record, again, this is what you filed in the trial court. You send it to the court reporter. I always try to reach out pretty quickly to the court reporter and ask if they want to be paid up front, if they want a deposit. Some court reporters, I'm sure all of y'all have relationships with them and they won't hassle you for the money. But if you're in a different county, sometimes they will. They want to be paid up front or whatever. So just make sure you're aware of that. But don't pay for a copy. A lot of court reporters will say, oh, well, do you want a copy? The answer is no, because you can get it for free on the Court of Appeals website. So don't pay extra for the copy. Also, something to think about, whether you used colored documents in the trial court or color pictures. They don't come in color on appeal unless you make arrangements for that. I'm in a case right now where my opposing counsel had this super fancy spreadsheet. I can't even do Excel, it makes me crazy, but it was colored. The columns were in color, the rows were in color, and it was really informative if you had the colors. But the court reporter just copied it black and white and got on a meal, and so it was meaningless. I mean, it had no value. I mean, there was a fix to it. They were able to go back and ask for the color copy, but do that on the front end if you know you've got color copies. Also, if you've got oversized stuff, you know, maybe you're down in Eagle Ford Shale land and you've got these huge land maps, ask for the originals to be sent to the Court of Appeals. So the Court of Appeals sees exactly what the trial court did.
Sure. Sorry, I have a question.
Sure.
If I already have a transcript for the hearing, say where the judgment was rendered, do I need to get another one? Is there anything different that the court reporter does for the appeal, or is that first transcript enough?
The court clerk, the court reporter should send it to the Court of Appeals.
Oh, okay.
They're the ones that actually do the transmittal. You shouldn't have to pay them.
Yeah.
Yeah, but just,
Okay.
you know, send that court reporter, hey, we're appealing.
Okay.
Please get this on up there. Yeah, that shouldn't be any problem.
Thank you.
And just like the clerk's record, make sure that you check for accuracy. Again, these you know, things can get miscopied and out of order and that kind of thing. This is kind of a funny thing. I'm in a case right now where somebody put a thumb drive into evidence, marked the thumb drive and offered it into evidence. I don't know what was on there. I think it was emails. Well, the court reporter just put the thumb drive on the copier and hit copy. So that's what's in the record on appeals. It's not one sheet of paper. It's a cute little picture of thumb drive. I mean, I don't care what my evidence, but I mean, plan ahead. Tell them we want the real thumb drive on to get to the Court of Appeals. And the docketing statement, this is in Rule 32. I don't know why I didn't put the rule up there. I think maybe because I had forgotten it's actually in a rule. Docketing statements to me are really kind of an antiquated thing. I'm surprised that we still have to do them. You know, literally typing in bar card numbers and addresses. You think it would auto-populate, but it doesn't. It's a form on the Court of Appeals website. When to file them, the rule says you're supposed to do it promptly after you file the notice of appeal. I think for a long time, people always thought that meant at the same time, file your notice of appeal, file the document statement. The courts of appeals don't really want you to do that. They want to wait until they kick out the letter that said, we got the notice of appeal, here's your cause number, now file the document statement. So don't get too worried about filing that really, really quickly. They're going to tell you when to file it. Sometimes people ask me this, how much detail should you put in a docketing statement? It asks you all those nutty questions, what are all the issues, what your case is about? And, I just say it's divorce or breach of contract, and what issues am I going to raise? Well, everything I need to get it reversed. I'm not quite that facetious, but don't go to any detail. They'll feel like I need to get pages and pages of stuff here. I don't think they read it, honestly. I think it's simply the clerk's office that uses it, so I don't get too worked up about that. And then it always has that question, how difficult is the appeal? Rate it from 1 to 5. I've never seen anybody put anything but 3. Is it easy? Is it hard? It's just somewhere in the middle. But anyway, yeah, just go ahead and do it. I'm hoping someday these will be outdated and we won't have to do them anymore. Or at least it could be linked to somebody's bar number. They could just do it. The clerk's offices, I think are super helpful. If you ever have a question, particularly Jeff Kyle is in Austin Court, he's super helpful and willing to talk to you and answer whatever questions you have. All the courts of appeals have a local rules or an internal operating procedure document on the websites, and those are pretty helpful. Sometimes you find stuff in there, maybe you really didn't know. So I would check on those, particularly if you get into a different court of appeals. You find yourself in Dallas or Texarkana or somewhere, you can check that out. And again, I've already mentioned the attorney portal, but that's how you access both the clerk's record and the reporter's record.
Sure. I have a question from Zoom, and it applies to your last slide. Do appellees and appellants both have to file the docketing statement?
That's a great question. I had written it down and I didn't say it. Some of the bigger courts require the appellee to file one. I know the Houston, the 1st and the 14th do, but it's only for a mediation statement. They just want to know if both sides are on the same page on not wanting to mediate. Because most courts are not going to make you mediate, but every now and again, both sides will check that box and say, yeah, we'll mediate. And so that's really why it's a smaller docketing statement. Good question. So let's switch gears a little bit. I'm going to talk about motion practice in the Court of Appeals. It's a lot different than in the trial court, where you can have a motion for just about anything in the trial court. It's pretty limited in the Court of Appeals as far as motions that you can file. The main rule is Rule 10. That's the standard rule for all motions and how you have to draft them. But the main one you're going to file is the motion for extension of time to file the briefs. That actually has its own rule, 10.5b. It's super easy. Just say the deadline, how much time do you want? But I really would give a pretty good reason on why you want the extension. I would not be too lax about that. I think everybody gets at least one free extension. I think all courts of appeals are pretty easy on that. But after that, make sure you are giving something tangible, I think, for the court to see. And just remember the certificate of conference. A lot of times people will forget. You do have to confer on that. I always try to confer at the very last minute, right before I file it. Oh, they didn't get back to me. I don't. But this goes to my next point. Don't oppose an extension. Unless it's just, somebody's about to, pass away, and it's a will contest, and it really makes a difference, or it's an election case. There's just virtually no reason. It's such bad karma. To oppose an extension. But anyway, I would encourage you to look at courts of appeals websites on extensions. I was talking to a colleague in Dallas, and they said the Dallas Court of Appeals has completely redone how they view extensions. And I think a lot of that's because that court is virtually completely flipped in the last 2 election cycles. And so they're doing it very differently. Apparently, it's really hard to get extensions up there. So be aware of that. And seriously take the letters that say this is your last extension. Really, they mean that. So if you get one of those, please try to live by it. A couple more motions. I didn't do slides on these. Motion to postpone oral argument. Sometimes you really do have a conflict and you just really can't do when they set the argument. But try to do that as quickly as you can. Courts have to give you at least 21 days notice of oral argument, and usually they give you about 30. But they don't really want to get your postponement motion 2 weeks before because they can't put another case in. And that's what they always are trying to do. If somebody has to back out, they want to move up the next case. And you have to have a little bit better reason than your motion for extension. The rule says that you must have sufficient cause, so it's a little bit higher standard. So, hopefully you'll have a good reason why you can't be there for oral argument. And realize too that some courts will just take you off the oral argument list. If you ask for a postponement, they just put you into, you're going to just be decided on the brief. So be aware of that. I would ask you to call the clerk ahead of time before you're filing a motion to postpone and ask if that's really what's going to happen. Motion to dismiss, that's under Rule 42. That's if you, sorry.
Later. Now, if suppose one party requests oral argument, and the other party does not request oral argument, is it usually they won't let you have an oral argument?
No, it's really up to the Court of Appeals. And now I think this is in the rule now, or most people do it. You do a little paragraph that says statement on oral argument. And so the person who wants it tries to say in a few words, please, 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 here's why you should hear this case. And the other side usually will say, here's why you shouldn't. But if you're the person saying, here's why you shouldn't, you also put a sentence in there that says, but if you're going to grant oral argument, I reserve the right to be there. I know the Dallas court, if you don't do that, you have to file a motion to be able to come in and argue. It's kind of nutty. So, I don't think the courts care too much. If one says we want it and one says no, I think they really do look to see if, they think it's worthy of their time. Oral argument takes up so much time. And so I think they're just pretty stingy with it. So motion to dismiss, that's just if you settle the case on appeal. You just file a short little motion saying, we resolve this. But that rule sets out, 42 sets out exactly what you need to do. And the last motion is a motion for rehearing. So this is after the opinions come out and you've lost. You can, one last chance, one last Hail Mary to see if they'll change their mind. They're super hard to do. About the only time it works is if a new case has come out and the Supreme Court's issued some new opinion that really makes a difference. Sometimes if there's a mistake in the judgment or the mandate, and you can convince the court there really was a mistake, it doesn't fit with your opinion and the judgment and the mandate, they're in conflict. Sometimes they'll grant a rehearing on that, but it's super, super hard to do. Now let's talk a little bit about briefs. Again, this is Rule 38. I'm not going to talk to you about the specifics of that, but I do want you to think about a few things. With so many people reading online, since we don't have page limits anymore, and now it's word limit, you can put really fun things in a brief. If you got a picture or you got a paragraph out of a document or, a graph, something that came into the trial court that you can then import into the brief. It really is effective. I had a filed brief this summer, and it involved a commercial dispute about a warehouse, and it was really a ratty warehouse that I was representing. And the other side was trying to make it sound like it was this Taj Mahal, super duper place. And luckily there were good photographs in the trial court, and I just put those in the brief, like on the second page. I wanted to see them from the very beginning. I didn't want them to have to look for it. Here's how ratty this warehouse really is. And I think that's really effective. And I've seen people, take out of a will, main part of the will or whatever, or, premarital agreement, whatever, and you slap that in. And it's just so much more effective than me just typing it in, and blocking. It looks so much better when it comes from the actual document itself. So I would really encourage you to do that and think broadly about that, because, briefs now, you'll get them, they're 70 pages because the word limit is all that matters now. So think about that. Of course, you have to bookmark and hyperlink. That's required by the rule. But I would encourage you to hyperlink to the appendix. Sometimes people forget to do that. You'll file this brief with a large appendix. Hyperlink back to the appendix. Maybe that's self-evident, but I see briefs pretty often that they haven't done that. Or they'll just hyperlink back to the first page. Like they'll hyperlink back to the findings of fact when really they should have hyperlinked to finding of fact number 9, right? Because that's really what they were talking about. So And same way with cases and statutes, make it super duper easy for whoever's reading the brief. Another thing that I think that you can be very helpful with this, when you're reading online, you've read 3 or 4 or 5 pages and it's just text, it's hard to read that. Get some headings in there, right? Get something to break that up. So it's not just all those pages and words. It's just so hard to read. Another thing on the on the appendix, do a table of contents when you get to the appendix. Here's your certificate of service, the next page, here's my appendix, here's what A, B, C, and D are. It's just, and then hyperlink from that. It's just so much easier than the first thing you see is exhibit A, and then, through T or whatever. And it's like, what's in here? You don't even know until you start looking through there. So I would do that at the beginning of the table of contents if you have any kind of lengthy appendix. Of course, the rule sets out exactly what has to be in the appendix. But you can catch this, when you're coming at the end and you're, whatever you do to get the page numbers into the table of authorities, I forget the word, there's a word for it, generate, whatever. But you'll see that, your folks are citing one case 20 times. That case probably ought to be in the appendix, right? And so just be aware of that. 2 more comments on briefs, redactions. For those of y'all who do family law, guardianship with minors. Rule 9.9 in the appellate rules is the rule about redaction, what has to come out. So kids' names, kids' birthdays, social security numbers. But you'll be surprised what is not redacted. You will see that here's the style of the case, the matter of marriage, blah, 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 and here's the kids' initials. Invariably, there's some motion or response filed somewhere that has the kids' names in it. And you'll get busted. The Court of Appeals will send it back. We're not going to file this. There's something's not redacted. So check for that. The other place I've seen where kids' names show up, but you think they wouldn't, and that's in child custody evaluator reports. A lot of times they will miss something somewhere and they'll have, Johnny or Mary or something in there, or the birthday is in there. So be aware of that. Another comment, and I'm sure there are people here who can explain this much better than I can. If your document has come from the court where they've signed the judgment, they've signed the findings of fact, and the courts lock that document, however they do that. And so you can't OCR it, right? You can't search it. But somehow you can. If you export it to Word and then save it as PDF, you recreate the document in effect, and then it's OCR. But courts of appeals will send those back too, because, well, it's not all OCR. We can't word search something. So I've been on the receiving end of that. That one's near and dear to my heart. So just a little bit about original proceedings. So this is mandamus stuff. So when you're complaining about just a particular order, again, hard to do, but you create the record. You don't go to the clerk. You do the record yourself. And so everything we've been talking about hyperlinking, make the record just as easy as you can. The only other comment on original proceedings is I would let the Court of Appeals clerk know if you're asking for emergency relief. If you need a stay, or you're trying to stop a trial setting that's next Monday and you're filing a mandamus today, call the court and say, we're asking for emergency relief. This is the relief we're seeking. Because that way the Court of Appeals can make sure people are around. All the judges, and they're not there all the time. But if they know an emergency relief motion is coming in, they'll get their people together, they'll get staff attorneys ready, and it just helps your client, their chances of getting a stay. Now I was going to talk a little bit about kind of the backside, what happens at the Court of Appeals as an appeal gets processed. And I'm hoping that this will maybe be helpful for you when you're talking to the clients. I know y'all are the big interface with the client, and they're going to have a lot of questions, and hopefully this will be a little bit helpful on kind of the inside part. So when the initial stuff comes in, the notice of appeal comes in, cause number gets generated. The next thing that happens is the record gets filed. And the record, if it's a regular 30-day notice of appeal, it should get filed within 60 days of the judgment. If you do the motion for new trial, it becomes 120 days after the date of the judgment. And of course, those are super fluid deadlines, right? Court reporters, sometimes they're really, really far behind. Clerks' offices, I think, are pretty good, but luckily you're out of it. That's purely between the Court of Appeals clerk, the district clerk, Court of Appeals clerk and the court reporter. You're not involved as long as you paid. They will bust you every time if you haven't paid. So make sure you pay for the record, because I think those court reporters love to say that. So-and-so hadn't paid me. So just make sure you've done your part and you're happily out of that program. So once the last record gets filed, then the briefs start happening. 30 days, 20 days for the reply brief. Those, of course, can all be extended. But then you get the notice of submission. And this comes out sometimes even before the reply brief is filed. It just depends how long your case has been out there. But the notice of submission is the document that comes out from the Court of Appeals that either grants your oral argument if you ask for it, or denies your oral argument. If it grants your oral argument, it's going to say, here's your oral argument date, and here are the 3 judges who are going to hear it. If it denies oral argument, it'll say your case is going to be submitted on briefs, and it gives you a date, and it tells you the 3 judges who are going to hear your case. Well, what does that mean when it gives you that your case is going to be submitted on a certain date? Well, that's the earliest that an opinion could come out. But other than that, it's pretty super meaningless and hard to tell. In the last 2 years of the Austin court, I had one case that said, I got my notice of submission in May, case is going to be submitted in June, and the opinion actually came out in July. Okay, same time period, I got a notice of submission for a certain date. It was a year later before the case came out. So it's very hard to predict, but that is something that clients are going to want to know. When you send them that notice of submission, they're going to go, what does that mean? And you can kind of say, it's hard to tell. Maybe it's going to come out, but maybe not. So kind of sad that it's not better able to tell people, but it's a real tough guess on that. So what do you do when you're sitting here waiting and waiting, post submission, all the briefs are in and you're just waiting? I try to monitor just sort of loosely. If I had a big case or a statute that my whole argument turns on, every month or so, just hop on Westlaw, see if anything new has come out. Because sometimes you find a diamond in the rough, right? I mean, another Court of Appeals has come out with something that's really helpful. You can file a little post-submission brief, kind of another way to get your case to the top of somebody's stack. So I try to do that. Sometimes it works, sometimes not. But I will tell you, it's a whole lot easier to file a post-submission brief telling them about a new case while your case is still pending, as opposed to the opinions come out and you're trying to do it on rehearing, because they are super unlikely to do anything on rehearing. Also call the clerk. If you've got a client that's bugging you about, how come my case still sits in Court of Appeals? And you can always call the clerk at the Court of Appeals and just say, hey, what's going on? And a lot of times you'll get some info, because they have deadlines too. Y'all all know this. The legislature has put deadlines, check marks on Courts of Appeals on how fast they have to get cases out. So they're not just intentionally holding stuff back. And a lot of times you call the clerk and they'll say, oh yeah, we know that's been pending for so long. They know it needs to come out. So sometimes that's just a client PR thing, but at least you can do that. Now, talking about clients, relationship with your client. Again, I know y'all are the main interface with the client, so I want to talk a little bit about that. I would encourage you, if you're going to do your appeal in-house, is do a separate engagement letter. I don't know how broad your initial engagement letter for the trial court work is, but you might be happier if you got your separate appellate engagement letter. For me, and I know a lot of people are this way, law firms don't really want to pay for the clerk's record or the reporter's record because they can get really expensive. $10,000 on a reporter's record for a 2-week jury trial with a lot of exhibits, that's not unheard of. And most law firms, I mean, maybe you've got a huge retainer and you feel good about dropping $10,000, but a lot of people, the retainers are not that high. And so, particularly when you're still talking about writing a brief, so I try to get them on the hook for that in the engagement letter. So they're going to have to write the check. When I get notice from the clerk's record, I just send it on. You got to pay it. That's something to think about. Educating the client. I think the big thing is for them to understand how different the appellate process is versus the trial court, right? The trial court, I know I'm going to say this and y'all are going to laugh, but at least in the trial court, you have some control over the deadlines, right? I mean, some little bitty control. I mean, you get to file the docket control order, you get to write in the dates, you get to pick the trial setting. Maybe it doesn't always happen, but you're involved in that. And as I've just explained in the appellate process, you have no control over anything. Once it starts, how long people ask for extensions, how long it takes to get the record on file, there's no control. And in a trial court, it's a little different than that. And also in the trial court, the client can go to depositions if they want, they can go to hearings. And whether they like it or not, they have to be involved in the discovery process, right? Most of them not, but they have to. Well, you don't have any of that in the court of appeals, right? I mean, I always send them the brief ahead of time before it's filed so they can read it and see what's going on. It's always entertaining because, you know, I represent mostly just regular people and they have such insight when they read a brief. I mean, sometimes it's stuff that's really kind of, you know, you just can't possibly include in there. But I mean, it's really fun to see someone, you know, who knows about the case, but yet to have them read the brief and get their comments on it. I think it's always fascinating, always helpful. But the client needs to understand though how long the appellate process is going to take. I mean, 2 years through the Court of Appeals is kind of how it works. You know, in the Supreme Court, that's a whole nother process. But they need to understand that. I would also make sure they understand about how the cost is going to work for them. Initiating an appeal, pretty cheap, not much to that. Then you're going to have the cost of the record, could be kind of a lot. Then you're going to have nothing until it's time to file the brief, and then you're going to get kind of a big bill. And then that might be it. Oral arguments denied, you're done. Oral arguments get set, you're going to get another little bill here at the end. Maybe not little, but let them understand that. And another thing I try to tell clients at the beginning, they forget it, but at least I can say, I told you that. You just forgot. That oral argument can be denied. A lot of times clients really freak out about that. Like, oh, the Court of Appeals must think our case is terrible. Why did they deny oral argument? Like, no, I told you at the very beginning. Most of the time they deny oral argument. So this is not a comment on your case. It's just how the process works. But I think it's helpful if you tell them that at the beginning, so they aren't surprised or disappointed or whatever. I used to tell people at the beginning about transfer jurisdiction. I quit doing that, knock on wood. I haven't had a case transferred in a while. But, you know, because that would happen a lot. You know, here you're in Travis County, you're going to Austin Court of Appeals, yay. And then we get sent to Texarkana or Amarillo. And clients really freak out on that. And I kind of freak out on that too sometimes because you're like, oh no, this would have been so much better at this court than that court. But it just has started happening so infrequently. I kind of dropped that from my spiel. I don't tell them that anymore.
Is that because the court in your area has just got too many cases?
Yeah,
it's looking at it like, oh, how not?
See, people say the latter sometimes, but that's just anecdotal. It's purely about how many cases get filed, and they look at it. I think it's by quarter. I could be wrong about that. I don't think they do it every month. I think it's by quarter. The Supreme Court looks at, you know, how many notices of appeal got filed in all 14 courts. And if there's an uptick in Beaumont and they got a whole bunch, and Austin didn't get very many, because I mean, really, there's no longer. It used to be always, oh, it's always transferred out of the big to the little courts. It's not that way anymore. I mean, you'll see little cases getting moved around from littler courts to not much bigger courts. But yeah, it's purely a numbers thing. I think that's all of the appellate stuff. Does anybody have any questions about the appellate stuff before we switch to the kind of trial court?
There was a question in chat when you were talking about briefs. She says, when referring to hyperlinks, is this the same as bookmarking?
No, it's not the same. The bookmarking, and I thought about doing this, but I didn't. You know, so if you want to bookmark something, you highlight and right click bookmark, and that puts it at the front. So like if you're looking at your documents on the left-hand side, that's the bookmark stuff on the left-hand side. When you want to hyperlink, you highlight it, right click, it'll say link, set link. And there are a couple of steps, but that's when you scoot into the document. Like here, I've got Roman numeral 1, standard of review or whatever. You know, I set my link, and then I go to page 10, wherever that is, and set the link. So it's a different thing between the two. I should have done an example, but oh well. They're different.
I have a comment.
Sure.
So I work for the Court of Appeals, and
Oh no.
it's all good.
I don't have anything there.
Just a couple of comments that you were talking about how fast things move in an accelerated appeal. And for those of you who work in family law, any parental rights termination case is an accelerated appeal. And that particular kind of case is on a very fast docket at the third court or at all the courts of appeals. And you were talking about the docket sheets, and
Oh,
you
sorry.
don't see a lot of purpose in them, but sometimes the the attorney for the opposing side, never you, I'm sure, and maybe fooled around and not gotten the clerk's record into us at an early time. And so there's a lot of information on the docket sheet that we can glean that we normally would look at the clerk's record for, like, do we have jurisdiction over this? Because any case that we're not going to have jurisdiction over anyway, we don't want to spend a lot of time on that case. And also, like in the trial, maybe one of the parties had one attorney, but then we see a different attorney's name show up on the docketing statement, and it's like, wait, what happened here? Because we want to make the notices go out to the right people. So the docketing statement can be real helpful to us in a lot of ways.
That's a good point about attorneys, a trial attorney versus an appellate attorney, because it's usually the appellate attorney doing the docketing sheet as opposed to the trial attorney. It says something like lead attorney, but then it's not really clear how you would designate one as to the other. That's a good point. But I think your first point is really, really good, because there's a statute. There's a statute on priority on what courts of appeals have to put at the top of the list, and that's the top one, I'm sure, for an termination. They have to do those first, and then, but there's a series of cases that they have to prioritize over just the mundane whatever. So yeah, there is an explanation for some of the delay that has nothing to do with any of us or how things work. It's just a statute. The legislature has said these are priority for a court of appeals.
Or the value of your issues.
Yeah, and you can see it. I look at the Austin Court opinions every month, and there's always parental termination cases. Always, there's never a month that goes by that there's not a handful of parental termination cases, because they don't have a choice. Those have to be done first. Thank you for.
And really
mentioning that.
anything that involves the custody of a child, like where the child's going to spend this weekend, is going to be at the top of our.
Oh
list.
yeah, for sure.
Yeah.
So that's a good sort of equalizing thing to make us all realize, it's frustrating for our clients, but yet the courts of appeals hands are tied on a lot of that stuff. All right, well, let's kind of quickly head over to some of these trial court things. I know y'all are going to laugh at some of these and say this can't really happen, but these are all things that I've seen that are practical things that are so easy to catch in the trial court that won't derail an appeal. And the first one is state of the pleadings. I know y'all are all laughing, but there's always a document control order, amend pleadings. Really, really take that seriously, and plaintiffs make sure all your claims are in, and defendants all your defenses are in. And here's the problem: cases evolve over time, and people come up with new arguments and new claims. It's just a lot of times those come up in a motion or a response or a brief in support of this, that, and the other, and it never actually got in your live pleadings. And the law is really clear. It has to be in the pleadings. Motions are not the same as the pleading. They're not the legal equivalent. So take the time to watch that, because I've been in cases where super great affirmative defense, but it was only in the trial brief, and that's waived. You can't do that. It has to be in the answer. So
I have a question.
yes.
So when you're doing that, is it more advantageous to do supplements, or is it more advantageous to do amendments?
I think amendments, but that's just me. Supplements make me crazy that I'm going to miss one. And some people are like, well, I don't want to have 5 amended petitions. I'm like, but it's all there, right?
Right.
You just added to it and supplement. It's like, did everybody see that? Is it going to be clear in the record that there were all these supplements? I think it's much easier to do amended, but I'm sure there's another opinion about that. But that's just what I think. Does somebody else think supplements better? Easier?
No.
I
Okay.
hate them.
I do not think supplements are better, but the argument I was told is that if you are doing multiple amended versions, and especially if the document's long, you kind of look at it and go, okay, what's the new part? Where's the supplements? I didn't like that argument.
I have seen someone do that where it was super long. They had kind of did a little thing at the beginning. This is what we're adding. We're not trying to be sneaky and hide stuff. It's just, it's a 50-page document, but here's where the new stuff is. Page 17, this paragraph, you could do that just to be user-friendly and transparent.
I was actually in trial with my attorney, this is one of my attorneys, in Williamson County, and Judge Kinnan got onto my attorney about supplementals to the petition.
Oh, really?
Yes. He did not like it, and he said, you need to start doing amendments. Don't do supplemental here, supplemental here. It's too hard for everyone. So
that's a good point. Can't be better coming from a judge. Okay, so I'll switch over to evidence. We could talk all day about evidence, but that would be awful. But I wanted to say these three things to consider. Was all your evidence actually admitted? Did the key question actually get answered? And did you get a ruling? And I know those all sound so super simplistic, but here's the trouble with what happens. By the time you get to trial, everybody knows who the key witness is, what the key question is going to be. Did you see that lady sign the will, or did somebody put her hand on that piece of paper? Who saw the light was red or green? Everybody knows the big question's coming and who it's coming from, right? They know the big documents. And so what happens? Your opposing counsel always objects when that good stuff's about to come in, whether they have a valid objection or not. They just want to disrupt what's going on. And then you look up, or I'll look up 3 or 4 pages later in the reporter's record when I'm reading it, and they never got that answer, right? They never actually said the words that you were all thinking they said, but they really never did it. Same way with evidence. You'll go on for pages and pages and pages, attorneys bickering over something, the judge talking, never got a ruling, and never got the document admitted. And I think that really falls on the whole trial team, but certainly on you all as well. For those of you who go to trial with your attorneys, be ready to jump up and say, you thought the witness said this, they really didn't say it very clearly. You really ought to ask it one more time, just so it's super clean on the record and they're not having to go, well, he said started the sentence over here, and then 3 pages later, God, that was the rest of the sentence, right? And also on documents, just make sure they all actually say admitted. And you can check that with the court report, right? They're supposed to be telling you what got admitted. So that's my evidence spiel. One other thing about evidence is offers of proof, right? I mean, that's so easy, but the problem is, attorneys get caught up in what they're doing and they forget the offer of proof, right? Your document got excluded, your witness got excluded. It's super easy on a document. You just walk to the court reporter and go, here's plaintiff's one offer of proof and you're done. But the problem is with a witness has been excluded. You're in a jury trial. Judges never want to do offers of proof because it delays the jury. I've even had a judge say, I can't do an offer of proof. And I'm like, well, yeah, except the rule says I can. But, watch for that because judges want you to do a summary. A summary is super hard to use on appeal. You need the question and answer format. The evidence rule 103C says they must let you do question and answer. So insist on that. I've been in a case where it was an expert witness was excluded, and the other side said, oh yeah, just look at the summary. My trial counsel didn't know to really insist on that 103 that I have to do this in question and answer format. It was virtually impossible on appeal to show what that evidence would have come in like from that expert. On the flip side, if you get someone's witness excluded and they're doing the offer of proof, the question and answer format, don't fall asleep. I've had that happen where my opposing counsel just kind of started working on something else. My witness is up there on the offer of proof, got everything in, they never objected. At the end of the offer of proof, I said, okay, Judge, I moved to have that admitted. He goes, yeah, it's admitted. And they had not made one objection. And so, that cuts both ways. But just remember, the offer of proof can kind of be a big thing. Video depositions, you see this as a problem sometimes on appeal. Court reporters are supposed to take that testimony down. They don't often do that. They start getting on their phone and fussing around. So if a video deposition is going to be played, I always try to go to the court reporter the day before or, on a lunch break. Hey, we've got this coming up. I just want to make sure you're going to transcribe it. And if she says or he says, I'm not doing it, my judge didn't make you do it, then you can take it up with the judge. And if he says no, at least to get that video deposition as part of the trial evidence, because otherwise the court of appeals is not going to see it.
Can you not just give the court reporter your page and lines? We've done that, and the page and line testimonies have just gone into the.
If they do
they'll
that,
take it.
yeah,
They're not required. to take
I
it.
just always want people to make sure that they know everybody's on the same page on how they're treating video depositions, particularly when you're doing cuts from it.
Mhm.
It's one thing to say here's the whole long thing, but if everybody agrees on the cuts, yeah, that should work. This is kind of your my current event, my proving up attorney's fees. I'm glad someone's here from the Austin Court because we're talking about Austin Court. So this is for folks who, DTPA, breach of contract, declaratory judgment. Lots of statutes have, the shifting of attorney's fees to the other side, right? Well, the Supreme Court's had a lot of opinions in the last 10 years about proving up attorney's fees and what you have to do that. And the fee has to be reasonable and necessary. That's a fact question. And then the judge decides whether it's equitable and just to actually, shift the fees to your opposing party. So the most recent case from the Supreme Court is called Roar Moose Venture versus UTSW Healthcare. It was from 2019, Roar Moose. That was a commercial lease dispute. And so the amount of controversy was about $300,000, but it was super lopsided on attorney's fees. Attorney's fees were over $1 million. And that was awarded in the trial court. Well, it got to the Supreme Court and they reversed the attorney's fee award and sent it back for a new trial. And they set out the standard. I don't think the standard is really any different than all of us in this room know. You have, your invoice has to show, what was done, who did it, how much time it took, when did you do it, and what was your rate, right? Like everybody's invoice. So that was really not anything new. But in that case, I don't think they had invoices. The lawyer just testified about why his fees were so much. And, and the Supreme Court said, well, that's just too general. You can't just say it was 40 bankers boxes full of documents I had to go through. We took 30 depositions. Oh, and the other side's a jerk. That's what they said. And that's what caused this to go up. But the Supreme Court did have some, like 3 comments that I'll kind of hang my hat on. And they say, we don't want to have attorneys, cross-examine each other for days on end about every little billable matter. So you're not going to have to go through, here's what we did on March 10th, here's what we did on March 11th. You don't have to do that. But it also says attorneys should not have to take a stand for days on end. And finally, it says we are not endorsing satellite litigation on attorneys' fees. So I think it is that they don't want the tail to be wagging the dog on this, but it's clear that the court is expecting a little bit more than I think what people used to do. Here's my rate, here's what everybody else's rate is, here's how much time we spent. I think those days are probably gone. But the case I want to talk about, which I think is super important, from the Austin court from August of this year, it's a memorandum opinion, but I don't care. It's Person versus MC Simpsonville, and it's got a lot of other little, parentheses stuff, but Person is the name of the case. And it's super important because it's the Austin court's interpretation of the Roar Moose case. But this is the part we have to hear. The court reversed a $250,000 attorney fee award. That's a lot. Reversed and remanded for a new trial because it was they considered it was not sufficient proof of attorney's fees. And here was the problem, like we've all done: overly redacted invoices. The invoices are not attached to the briefs, so you can't see the invoices, but the opinion quotes from them. And it's like we've all done. Meeting with blank regarding blank. Office conference with blank regarding blank. Research regarding blank. Nothing was decipherable from those invoices. You couldn't tell what anybody was doing. It was really unfortunate. The court said they were heavily redacted to the point that we couldn't tell what task was performed. But the court was really careful to say this: it's not just the redactions. Everybody's going to redact, right? We've got stuff that's privileged. You have to redact. But the court said, look, you're going to have to balance those interests between what you think is privileged and how you're going to prove reasonable and necessary fees. And so you're going to have to really be careful about that. And I think we really have to kind of take a step back and reanalyze what we think is really privileged. Because a lot of stuff that we're told, oh, black that out, it's not privileged. We're just have always been told to do that. And I think you're going to have to really step back on that program. The other part of Person that is that case that's important, the attorney testified too. So not only did the invoices come in, but the attorney testified. And the court said, look, it was just too general. There was not enough specifics in the testimony. And again, reversed it for a new trial. I mean, what I would suggest you might consider, and I don't have the answer, this is just kind of me thinking about these cases, is you might get together with your trial team on the front end. When one of these cases comes in the door and you know it's going to be an attorney's fees case, and talk about how you ought to put your entries in the invoice, right? You don't have to say, call with Dr. John Smith at UT Medical School as a potential expert on causation, right? All potential expert on causation, right? You don't have to put their name. You don't have to give every little bit of detail. Just figure out what you don't want to give. And I think that can be done in a way that you're still informing the client of what you're doing, which is important, but you're also not putting in so much detail that 3 years into the lawsuit, you got a stack of invoices that are going to be redacted, because you can't do that anymore. So I would encourage you to read that Person case, read Roar Moose, take it back to your trial teams, and have a discussion about it on the front end, because it's not gonna be any fun to deal with that and go through years worth of invoices. At the end, I see I'm getting to the end, and I don't want to overextend my time. So I will wrap up, and thank you again for letting me come here today. If you have any questions, please, give me a shout. Happy to talk to you. Thanks.
Laurie, thank you so much. Did anybody have any questions?
She darted out.
No, from Zoom? Okay, very good.
Sorry, I didn't warn you that we
She probably shouldn't be up there talking.
Keeping you on your toes. This year, CAPA has started thanking our speakers with a donation to a charity of their choice. And Laurie chose the Settlement Home for Children. The home is a licensed nonprofit organization that serves individuals who have experienced severe emotional trauma, abuse, and neglect. They provide 24-hour care to help children in foster care access the materials and support they need to restore and preserve a